thank you for joining us. My name is Katie Perez, and I am a senior associate at Scott Legal PC. Today, we're going to spend some time talking about the L-1 and EB-1C visa options. Just a few things before we get started. Some of you may know that our firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the US on an E-2 visa and has been on several different visas, including the F-1, a TNB, and an H-1B. Scott Legal PC is a full service immigration law firm, and we offer immigration services in a variety of different areas, including the E2, E1, TN, family immigration, L1, national interest waivers, EB-5, and extraordinary ability visas, and more. We will continue this webinar series doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today. We will send you a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. This webinar will be recorded and available on YouTube. We will also send the link for that. So we do encourage you to subscribe and hit the notification button, as we do regularly send out and upload immigration videos on a variety of topics. We'll also send you a link where you can arrange a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you have any questions throughout the presentation, please put them in the chat box and we will address them at the end of the presentation. So today I will be presenting the first half of the webinar. My background does include 10 years of experience with USCIS, where I did adjudicate the L petitions. We also have our partner here with us today, Kelly Weiner. She will also be presenting, and Kelly is a partner with Scott Legal PC and has extensive experience processing employment-based visas to include the L1 and the EB-1Cs. So let's get started here. Okay, so what is the L visa? The L-1 visa is a non-immigrant temporary work visa that allows the company to transfer certain qualified employees serving in managerial, executive, or specialized knowledge roles from one of its foreign offices to a related office here in the US. So there must be a qualifying relationship between the foreign and US companies. The qualifying relationship between those companies can be that of a parent, subsidiary, affiliate. Oops, I'm sorry, I thought I skipped. Oh, sorry, I thought I skipped this chart slide. The qualifying relationship can be between that of a parent, branch, subsidiary, or affiliate. The non-immigrant classifications for this section of law are that of the L1A and the L1B. So the L1 visa can be an option for a company that has been doing business for an extended period of time, so at least 1 year or more, and wants to send a qualified individual here to the US. However, it can also be an option for companies that have not been doing business here in the US, but are looking to grow and expand their business here. So companies who have not been doing business in the US can apply for what would be called a new office. A new office would be defined as an organization that has been doing business operating in the US through a qualifying organization for less than 1 year. So both the L1A and the L1B petitions can be filed as new offices as well. So let's talk a little bit about the specific requirements for the L1 visa. So first, again, the qualifying relationship. When an employer wishes to transfer an employee from the foreign company to the US company as the L1 non-immigrant, they must demonstrate in part that the companies have this qualifying relationship. Again, the types of qualifying relationships can include parent, subsidiary, affiliate, or branches. Here it is very important to look at how the companies are related, because there are specific definitions in the immigration regulations for each type of relationship. So before filing, it would be important to look at documents such as the operating agreement, other formation documents, to really determine the ownership and control of each organization. So although you may think the companies fall within one of the definitions, they may actually not fit in. So for instance, you could have 2 companies that may have some common ownership between the 2 of them, and those companies may define their relationship with one another as an affiliate just because of a partially shared ownership. But under the regulations, they don't necessarily meet the definition. For an example, if you have company X owned by A, B, and C, each owning about 33% of the company, and then you have company Z owned by A, B, and D, also each owning about 33% of that company. Although a large portion of both companies are owned by the same two people, this would not actually meet the definition of an affiliate based on just these very basic facts. So here, the same group of people don't actually own and control the companies. Of course, you would want to go beyond the basic facts, and different types of agreements between companies and people can affect the ownership and control. But that would be on a case-by-case basis. So it is important to do the analysis before filing to ensure that foreign and U.S. companies have this qualifying relationship that satisfies one of the definitions. You also have to show that the foreign and U.S. companies are both doing business on an ongoing basis. Doing business is defined as the regular, systematic, and continuous provision of goods and or services. Therefore, you need to show proof that both companies are actively doing business, actively trading. Typical evidence for this would probably include your taxes, invoices, or things to show the sales, stuff like that. There is no statutory or regulatory minimum level of business activity to show that you're meeting this eligibility requirement. Determining whether a company is doing business in accordance with regulations is really on a case-by-case basis. So here the government would likely look at things like the type of business you have, what are the needs of the organization. So if you own a business and you're selling goods and you provide as evidence some invoices for maybe January 2025 and August 2025, but you have low revenues, maybe you have little to no employees, the government would likely say you're not necessarily conducting regular business. You're conducting some business, but it's not regular. So it would be your burden to show that you're doing business in accordance with regulations and it's regular, continuous, that sort of thing. The doing business requirement does impact the type of petition you would file. So we did touch upon this in the previous slide, but again, if the U.S. company is a startup company and they've been doing business for less than 1 year, it means that their L visa would be for a new office. With the L visa new office, the company would have a year to really get the company up and running and to start doing business. So you don't need to show regular business at the time you file the petition. You do have a little bit of time to get the company running and in order. Another consideration would be where an organization may have a legal existence in the U.S. for more than 1 year, but if it has not engaged in the regular, systematic and continuous provision of goods and or services for more than 1 year, then it can still be defined as a new office. So this could be a good option for a situation like that. An example of this would be maybe the U.S. company incorporated about 2 years ago, but it's just been this passive entity, not really doing much. There's been no trade, no sales. The tax returns may show little revenue, but so this would not really qualify for a normal L-1 petition. But if you plan on starting to do business, planning to start the trade, then you could potentially qualify for the new office petition. One more thing regarding the doing business, it is important to remember doing business does not include just the mere presence of an agent or office of the qualifying organization in the U.S. and abroad. You do need to show the activity. So another requirement would be that the employee has at least 1 continuous year of full-time employment abroad with the qualifying organization within the 3 years preceding the filing of the petition. So the employee's prior year of employment abroad must have been in a position that was managerial, executive, or involved specialized knowledge. There are very specific definitions for each of these types of positions. We will discuss those in just a later slide. So for the L-1A, which is for the manager and executive, you can be approved for initial grant of 3 years. You can then renew for increments of up to 2 years for a total of 7 years. For the L-1B, which is a specialized knowledge position, you can be approved for initial grant of 3 years as well, and then also renew in increments of up to 2 years for a total of 5 years. You can also recapture time. So, for example, if you spend a few weeks out of the year abroad, you can recapture this time under the L. So you can remain as an L in the US for a total of 7 years. Then time spent outside the US would not be counted against that clock. So it is helpful to keep track of your trips. While the government may have most of your travel records, on occasion they don't have the complete record. So it would be your burden to demonstrate that you are eligible to recapture the time. So it is important to keep track of that information. Okay, so we will discuss now a little bit more in detail the new office requirements. So again, the new office is an organization that has been doing business in the US through a parent branch, affiliate, or a subsidiary for less than 1 year. If the company is sending the employee to open the new office, there are some additional requirements. We'll discuss those. One of the requirements would be proof that the company has secured a sufficient physical premise to house this new office. The physical premise really needs to make sense with the type of business you plan on conducting. So let's say you plan on doing an import-export business. You indicated in your business plan that you want to hire 7 employees, that you would need a warehouse, that sort of thing. So if you provide the government with a lease that is for 100 square feet, it's an office, it has 1 desk, but no warehouse, the government might say to you, you haven't satisfied this criterion. So here if you've indicated in the business plan you need a warehouse, but you haven't explained how you will do business without this warehouse, or even space to house these 7 people, they will want to see that what you have laid out in the business plan matches up with the evidence that you've provided, like the lease. Regarding the physical premise requirements, this has become a little bit more malleable in the recent years, especially with the pandemic. However, the government doesn't typically like to see the co-working spaces, so that could also receive pushback. But again, as long as you demonstrate in light what you're claiming, what you're providing as this physical premise makes sense in light of the business that you will be conducting, it shouldn't be too big of a hurdle to overcome. It's actually not something they focus on too much. So at the time of filing, you need to show you have what will be needed in what you've explained in the business plan. So if you're coming as an L-1A to open the new office, you must still show that you've been an executive or manager for 1 continuous year out of the 3 years preceding the filing of the petition, and that the proposed employment in the US must involve managerial executive authority over this new operation. So if you're coming to the US to fill a managerial or executive capacity role, your qualifying experience abroad should have been managerial or executive capacity role as well. So unlike other L-1 petitions, eligibility for the L-1A new office approval you cannot satisfy it by the qualifying experience could not have been with a specialized knowledge role. You do not need to have employees before you apply for the L-1A new office, but you do need to show that the US operation will support a managerial or executive position within the 1 year of approval. So in order to determine if this US operation will support a manager or executive position, the government will want to see things like the scope of the office, the organizational structure, the financial goals of the company, the hiring plan, how you plan to accomplish the goals you've laid out in your business plan. They'll want to see the size of the US investment, the financial ability of the foreign company to pay the employees to start this business in the US. Things like, will the foreign company capitalize the US company? So with new offices, sometimes you might see the government say you need to show that the foreign company can capitalize the total expenses, but this is not necessarily required. It's not actually in the regulations, but it is important to show that the foreign company has funds, is solvent. So as a previous adjudicator, I remember seeing cases where the foreign company did have negative balances in their bank accounts or little to no funds. evidence like this would be a red flag. So while you don't necessarily have to have all the funds, the foreign company should be able to show they can at least support the U.S. company and pay the U.S. Employee. So another consideration would be, will the foreign organization support the U.S. company with personnel, and in what capacity will this personnel help support this new office? So maybe for the new office, you don't have plans to hire administrative support, but the foreign company will provide this. Or maybe you, as the new office employee, will do these duties initially, but it is understood that the manager or executive who is required to open this new business may be more actively involved in the day-to-day administrative duties for the new office in the initial phases. But this person needs to have the authority, the intent to hire staff, have this wide latitude of decision making to really get this company up and running. And you need to show that you will have this sufficient personnel to support the executive or manager by the end of year one from primarily performing the administrative and operational duties of that business. Okay, so for the L-1B new office petition, we'll discuss a few of those requirements. So for the L-1B new office, this would be for someone who has served in a specialized knowledge role abroad for at least 1 year and is coming over to the U.S. to also serve in a specialized knowledge role. So you need to show the employee possesses specialized knowledge, that the U.S. foreign positions involve specialized knowledge. We will discuss more later on just what is specialized knowledge. But you do still need to show that you have secured a sufficient physical premise to house this new office, which we just previously discussed. That requirement is the same. Then you need to show that the petitioner has this financial ability to remunerate the employee and commence doing the business in the U.S. Okay, so again, the L1 is specifically for those that can be classified as an executive, manager, or a specialized knowledge employee. And again, these each have specific definitions. So we'll start with the executive capacity definition. So the executive capacity means it's an assignment within an organization in which the employee will primarily direct the management of the organization or a major component or function of the organization. They will establish the goals and policies of this organization, component, or function. They will exercise wide latitude in discretionary decision making and receive only general supervision or direction from higher level executives like the board of directors, stockholders of the organization. So to just demonstrate executive capacity, you need to show that you or the employee will perform certain high-level responsibilities. You need to show that this employee will be primarily engaged in those executive duties as opposed to the ordinary operational activities alongside the lower level employees. So it is important to provide a detailed description explaining what you or the employee will be doing on a daily basis and that their duties are primarily executive in capacity. So if you're choosing to classify yourself or another employee as an executive, it is really important to describe the role in a manner that lines up with the definition and support that description with evidence. So for example, the definition states that the executive must direct the management of the organization. So an executive directs the management of the organization, major component, essential function of this given organization by controlling other managers or lower level executives. This control can be direct or indirect in some circumstances, but if you're claiming executive, you need to show that you have a management to direct. So showing that other employees serve as managers within this organization. Most commonly, you would see someone who's serving as an executive with a multi-tiered structure. So you would likely have the applicant or employee overseeing managers, and then that manager is overseeing other employees within the organization. That would help to support that this person is really serving at a high level, performing high level responsibilities. So again, in order to demonstrate you're an executive, you'd want to really detail your duties, provide a percentage of time. This will really help show that you're primarily performing executive duties. You would want to detail the structure of the organization. It's helpful to provide a duty description for the subordinates as well. Having an executive title alone won't be sufficient. So you really do need to think about the structure of the company. How many employees do you have? What are needed? It's not just about the job title. It will be about the substance of the job. So what you're doing on a daily basis. And if the structure isn't really there to support someone in an executive position, because maybe it's a smaller company, you may want to try for a different category like managerial or a specialized knowledge role as opposed to the executive position. So we will now go ahead and switch over to our partner, Kelly Weiner. She's going to go over managerial capacity.
Thank you, Katie.
Mhm.
Perfect. So, similar to how there's a regulatory definition for executive, there is a regulatory definition for manager, and they do look at this very closely. So you really need to make sure that, the employee you're putting forth for this role actually kind of meets these criteria. So it's going to be somebody who manages an organization or a department, subdivision, function, or component of the organization. If they are a personnel manager, they need to supervise and control the work of other supervisory professional or managerial employees. So if you kind of are a frontline supervisor and you're supervising people who are not supervisory or professional or managerial themselves, then that doesn't qualify. And when we say professional, we mean a job that requires at least a bachelor's degree to perform. You also can manage an essential function within the organization. So there's kind of two types of managers. One is a manager of people, and another is a manager of a function. So if it's the type of job where maybe you don't have direct reports, but you do have a lot of indirect reports who are kind of doing the actual work and you manage that function, that can also be something that can qualify under a manager. If you're a personnel manager, you have to have the authority to hire and fire, or recommend personnel actions, promotion, leave authorization, things like that. If it's a function manager, you have to show that the person functions at a senior level within the organizational hierarchy or with respect to the function managed. This can be shown by things like, do they have discretion in decision making? Are they attending meetings with kind of the top level executives or other senior managers, where their opinion is kind of taken into account? Um, Finally, you have to show, that you exercise discretion over day-to-day operations of the activity or function. So again, here they reiterate, a first line supervisor will not be considered to be a manager. So sometimes, depending on how, the structure of the company is set up, even if somebody may have a C-level title or consider themselves an executive, if there isn't really a structure, a manager may still be a good option for that type of employee. And if you are transferring and maybe you were an executive abroad, you can also have a different role in the US and perhaps be a manager. So you really want to look at kind of what are the job duties, what is the structure of the company when deciding, what category does this person fall into. You can go to the next slide. All right, so let's talk about what is specialized knowledge. So we've talked about the L-1A executive and manager, and if you want to get an L-1B, you have to show that you have specialized knowledge, which means special knowledge possessed by an individual of the petitioning organization's product, service, research, equipment, techniques, management, or other interests, and its application in international markets, or an advanced level of knowledge or expertise in the organization's processes and procedures. So with either of these types of knowledge, you have to show that the beneficiary's knowledge is not commonly held throughout the industry. So for these types of applications, you're kind of always going to be making somewhat of a comparison. What do people in the company know? Or what do people in the field at large know? And how is this knowledge that the person has kind of special or distinct? Um, So if you're looking at specialized knowledge, you want to show how that knowledge of the petitioning organizations, what it produces, kind of what it does, So for example, if there's kind of proprietary technology that's being deployed, or perhaps there is a particular, kind of type of service that is offered, and this person, has that particular knowledge, and you can demonstrate that it's not commonly held within your company and throughout the industry, that can be helpful. Advanced knowledge, sometimes this can be very helpful maybe for somebody who perhaps is earlier in their career. So it may be hard to argue that this person has, so much more knowledge compared to others in the industry. But let's say this person kind of came up with the company, as the company grew. Maybe the company started very small, and now has hundreds of employees. And this particular employee developed kind of a certain, proprietary process or procedure or something within the company that has now become very important, and they're the point person for that. So that can be a way sometimes that if someone is kind of earlier in their career, maybe doesn't have as extensive experience broadly, but has a lot of experience with this particular company and its growth trajectory, that can be a good option, for specialized knowledge or arguing advanced knowledge. All right, so let's turn and talk about what actual documents need to be submitted for an L-1 petition. So one would be the form that you submit to U.S. Citizenship and Immigration Services. That's Form I-129. You also have to submit the corporate documents showing the qualifying relationship between the companies. If there's any kind of documents that are not in English, those all have to be translated into English for the submission. Proof that each company is doing business, so company tax returns, audited financial statements, lease agreements, invoices, payroll summaries, internal organizational charts. You also need to include proof that the employee has worked for the company abroad for one continuous year out of the past 3 years in a managerial, executive, or specialized knowledge role. So this will have kind of a few different types of evidence. One would be pay stubs, showing the employee relationship for at least a year. If there are personnel records on kind of specific trainings or any special knowledge this person has. You also want a detailed job description that kind of clearly identifies which category the person is in. Are they an executive, manager, or specialized knowledge? You cannot kind of combine that and say, well, they were an executive manager. You really need to kind of pick one category and explain how they meet that criteria. Organizational charts are very important, in particular for, managers and executives. Can also be helpful for specialized knowledge workers just to show where they sit within the hierarchy. Work product is also, quite helpful, in particular for specialized knowledge cases. Work product can be very important, as that's, a kind of objective way to demonstrate, that the person kind of does have this specialized knowledge. You also have to include proof that the employee's role in the U.S. will qualify as managerial, executive, or specialized knowledge, and you'll submit kind of similar documentation. As I just discussed in the prior slide, you do not have to have the same job abroad and in the U.S. You can be being, a CEO, being transferred to be a CEO, but you also can be, maybe as a manager who's now getting a promotion and is being transferred to be an executive. If the role is different from the role that you held abroad, then you will also need to provide evidence showing that the person is qualified for that role in the United States. So you want to include an explanation of how any kind of, experience or education that they have, lends itself to them being able to successfully perform this job in the United States. All right, let's talk a little bit about requests for evidence. So requests for evidence are unfortunately quite common for L1s, although they have dropped over the past couple years in late 2024 and early 2025. They were not as significant. However, there are kind of trends that do show that at times RFE rates have gone above 50%. And certainly in an environment where there is kind of more scrutiny on all immigration petitions, we do expect that, RFE rates may start to rise again. Most of the requests for evidence for an L1 will challenge whether the applicant meets the definition of manager, executive, or specialized knowledge worker. Even if there's kind of other issues they address, this is often thrown in, or sometimes it's kind of the main point that they will challenge you on. And this is where we talked about earlier. There's these very specific regulatory definitions of who qualifies, and they do stick to that quite closely. So detailed support letters and organizational charts with details about kind of other employees in the applicant's department can be very helpful. But you always want to kind of supplement this type of evidence with objective evidence if you can. So you want to be able to support, any statements that you make about the job duties, about the organizational chart with objective evidence. This can be things like work product with kind of explanations for what's being shown, internal email chains, perhaps if the person is kind of regularly corresponding with kind of all the executives in the company, if there's any kind of policy handbooks the person wrote, if it's a manager and you're trying to prove, they do performance reviews or they authorize leave, those can all be very helpful. And then, as I mentioned, for specialized knowledge, you can, often show this, what work product is being created, why is this so important to the company, and this can be very helpful for the officer so that they feel this isn't just a letter written by the employer saying they meet the criteria. There's actual documented work product as part of their workflow that shows that they meet the criteria. All right, let's talk a little bit about timing and also dependence. So the way that the L-1 petition works is first, it has to be submitted to U.S. Citizenship and Immigration Services on Form I-129. Processing times are several months, even sometimes up to and over a year, although usually a bit shorter than that. However, there is an option to pay an additional fee for premium processing to get a response within 15 business days. So this can be an approval, a denial, a request for evidence, or a notice of intent to deny. If it's a request for evidence, you'll be given, usually 87 days to respond. If it's a notice of intent to deny, you'll be given 30 days to respond. And then once they receive your response, you'll get a final answer 15 business days after that. Very rarely, they might issue a second RFE, so they have the ability to do that, but that's quite rare. If the petition is approved by USCIS, then at that point, if the employee is outside the United States, the next step would be to schedule an appointment at a U.S. consulate to get the L-1 visa stamp. If the person is already in the United States, let's say maybe they entered briefly on a B-1 and did a change of status, then they would just get an approval and remain in the U.S. But once they wanted to travel, they would need to go to the consulate to get the L-1 visa stamp. Spouses and unmarried children under 21 can accompany the L-1 visa applicant on L-2 dependent visas, and the L-2 visa status does give the spouse the ability to work. The children cannot work but can attend school. All right. So, a very common question, does an L-1 lead to a green card? And so for any temporary visa, there's no kind of automatic path to a green card. So for example, just because you're granted an L-1A, that does not mean will automatically be approved for an EB-1C. That being said, it is a common path that people might move from an L-1A executive or manager to the EB-1C multinational manager or executive green card option. So if you are eligible for it, then you can apply for it. But again, it's not an automatic process, nor does getting an L-1A automatically mean you'll get the EB-1C. So for the EB-1C, there are very similar requirements to the L-1A, but it's a heightened standard because this is a green card. So while the L-1A is temporary and after 7 years, you need to depart the United States, the EB-1C allows you to live and work in the United States, long term with that green card. And so they do apply a heightened standard. So they will look at, is there a qualifying relationship between the company abroad and the U.S. company? Both companies must be doing business, and the U.S. company for an EB-1C has to have been doing business for at least 1 year. So that's a bit different than the L-1, where you can apply to open a new office. The employee does have to have worked in an executive or managerial role for at least one continuous year in the past 3 years. If you're already in the United States working on an L-1, for example, they'll adjust the time frame for looking at the employment abroad. A big benefit here is that there is no labor certification required. So under the, more common process to sponsor somebody for a green card through a US company, there's a labor market test that you have to go through. So the EB-1C waives that, requirement. You don't have to engage in that, which is a big benefit. Um, I will say again, like, let's say that you got an L-1A, but there was a really big RFE that you had to overcome because they didn't really believe that you were a manager abroad. That can come back again, when you file for an EB-1C. And because they apply that heightened standard, just because the L-1 was approved, maybe with only a few, employees abroad, it doesn't mean that they'll approve it for the EB-1C. So if there was a, very difficult L-1 approval, or the company abroad was very small, and it was hard to make an argument for an executive or a manager, that can become kind of a stumbling block for the EB-1C down the road. Um, so you do have to have been in an executive or managerial role abroad to be able to, and in the United States to be able to apply for the EB-1C. So for an L-1, let's say that an L-1A, let's say you had a specialized knowledge role abroad, and now you've come to be an executive. You can get the L-1A, you won't be eligible for the EB-1C because your role abroad was not executive or managerial. Moving to the L-1B. So the L-1B, if you're here on a specialized knowledge, worker visa, you won't be eligible for the EB-1C. So that is limited only to managers or executives. So if you're on an L-1B and you're interested in a green card, you would need to go through the perm process. So this is where the U.S. company is going to get a prevailing wage determination, test the U.S. labor market for willing, qualified, and available U.S. workers. And if there are not any, they can kind of proceed and sponsor the worker, for a green card. And we do have another webinar that goes over the perm process in more detail. It is quite complex. But for purposes of this presentation, we won't go into it in more detail. All right. So let's see. It doesn't look like any questions have come in. So I think we can close here.
Okay, thank you.
Thank you, everyone. I hope you have a wonderful day.
Bye.